In our last lesson, we considered the marginal revolution, a moment in the history of economics, the transition from what we can call classical economics, the economics of Adam Smith and David Ricardo, John Stuart Mill, and in a way Karl Marx, and the rise of a new kind of economics, neoclassical economics, an economics that is grounded in the recognition of how markets actually work, that they work by a supply and demand mechanism that accounts for marginal utility and marginal costs. And it's a technical but very profound idea that's the discovery of William Stanley Jevons, that people value things based upon the additional happiness that they derive from the consumption of it. And so Jevons' vision of marginal utility is deeply grounded in a type of utilitarianism. In fact, a kind of utilitarianism that's deeply indebted to Jeremy Bentham. And Jevons begins from the position that Bentham articulates, that human beings are subject to two sovereign forces, pleasure and pain. And marginal economics is capable of explaining how markets work in terms of a kind of Benthamite utilitarianism, that they allow people to derive a great amount of happiness because it allows people to exchange goods, it creates incentives that are ultimately tied to people's wants. Now, one of the challenging aspects from a moral or philosophical perspective about marginal economics is its value proposition, its value theory, because it ultimately reduces all values to subjective preferences, to what individuals ultimately want. Now, in this lesson, we turn away from marginal economics and come back into the legal and constitutional tradition. And we need to look specifically at the way that the legal and constitutional tradition develops in the context of the United States. And in particular, in the United States, amidst the process of industrialization. We've explored how Smith and Marx are observers of industrialization, the revolution that ushered in the age of capitalism. And for Marx, this is a transition from feudalism, from a social order where people inherit a network of obligations based upon their status, to a society where people are nominally free and equal. It's a society that is suffused, that is shot through, that is full of contractual relationships in which people are exchanging and contracting on a daily basis on a scale that had never existed before. And we want to see how this reality intersects the tradition of the U.S. Constitution. Now, in talking about the establishment of the American polity, we've talked about the way that it was founded at a moment that was pregnant with enormous change, that it's founded in a radical Republican revolution, but that it's founded also at a moment of enormous transformation. 1776 is not only the year of the Declaration of Independence, it's the year of Adam Smith's Wealth of Nations, which represents the first work that truly, profoundly understands the consequences of economic change, with its recognition of the division of labor and the rise of markets. Now, the American founding, broadly conceived, in a way that incorporates both the Declaration of Independence and the U.S. Constitution that is drafted in 1787, is, in a way, a very Lockean revolution as well. And it's a Lockean revolution that is built out of a synthesis of Whig ideology that views individuals as naturally free. And the idea of natural rights is embedded both in the Declaration of Independence, which declares that all people are created free and equal, and it's embedded in the Bill of Rights itself, the first 10 amendments to the Constitution that are included as part of the process by which the Constitution is ratified. Remember that the Bill of Rights are actually the legacy of the Anti-Federalists, those who opposed the Constitution in many ways. But the Bill of Rights articulate, they express what were believed to be some of the most fundamental individual natural rights. And they were meant as a guarantee, as a kind of express declaration, a just-in-case expression of what rights of the individual were inherent, were natural, and could not be violated. So the Bill of Rights were to act as a guarantee of a set of natural rights. And the Bill of Rights, as is explicit in the Bill of Rights itself, is not meant to be an exclusive list. It's simply a list of ones that are so important that they need to be expressly declared. But the idea that the individual derives these rights from nature and not from a government grant or from some kind of sovereign cession to the individual or the people means that the individual reserves, more broadly, the natural rights. Rights like the right to life, liberty, and the pursuit of happiness. So let's think about what the right to liberty means in the context of industrialization and in the context of a new kind of social order that arises in America across the 19th century, and particularly by the late 19th century has acquired enormous momentum as America has gradually and progressively ceased to be the kind of Jeffersonian republic of small individual farmers that Jefferson imagined at the beginning of the republic, and has gradually become an urbanized, industrialized society with manufacturing sector taking an ever larger part of the economy and coming to dominate social relations as well. It's in that context that we should explore some striking Supreme Court cases that themselves represent not only monumental moments in American history and in the definition of our constitutional and legal order, but represent an opportunity for us as students of law and justice in the broadest terms, the broad history of law and justice, allow us to look at the way that the American constitutional order encounters basic fundamental principles of justice. So, over this lesson and the next several lessons, I'd like for us to consider a series of Supreme Court cases. And it's important that we, at least at some very, very basic level, understand the constitutional law that's at stake, the way that these questions are framed in terms of the American system of constitutional law. But that's not what I want us to focus on. Instead, I want us to step back from these decisions and to read them as statements of justice, to read them like they were philosophical texts. These are cases that allow us to stand outside the specific legal and constitutional tradition of the United States and to ask, not are these rightly decided in terms of a constitutional tradition, but are they rightly decided in some objective, some legally neutral space where we can judge using only our reasoning and the principles of justice that we've explored in this class. And so it is from that perspective that I'd like for us to look at a case of 1905, Lochner v. New York.